Mr. Burnett, what case are you here on?
Good morning, Your Honor. I'm here for LAFCU versus Angela Woods.
All right. All right. Mr. Groen, what case are you here on?
I'm here on the Resurgent Receivables Joel Smith matter.
All right. Thank you. And Mr. Cox, what case are you here on?
I'm here on Meemic versus Varela-Baroto.
All right, I see that. All right, I'm just checking to see who I've got in the courtroom, and I'll call cases in about 2 minutes. Ms. Baker, you're here on John Pavlik versus Cassandra Fascino.
That's correct, Your Honor.
All right, let's go ahead and call that case. We're on the record in docket 1202493. That is John Pavlik versus Cassandra Fascino. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Denise Baker, P53670, appearing on behalf of plaintiff.
And ma'am, you are Cassandra Fascino, correct?
Correct.
If I remember correctly, the last time we were here, that there were supposed to have some documents. This was an order on to the objections for garnishment. And we took Ms. Fascino indicated that there were some documents indicating that she had made payment in this matter. We went on the record and we got a number and a email number. The documents were to be sent to in order to better facilitate some of the communication between the parties. Ms. Baker, were you able to receive any type of paperwork from Ms. Fascino?
Yes, we have, Your Honor. We also communicated with our client, and we did confirm that there was a $3,090.59 adjustment that needed to be made to the judgment balance due to a prior garnishment payments. This account had been referred to our office for collection on the judgment, so we were not part of the original garnishment. As of today, with the current garnishment payments, we're showing $2,509.15 as the current balance.
And is that your reading of it?
Yes.
Okay. So this is now, so now we got the number, which is what we wanted to get. All right. So where do we go from here? I mean, do you still have, so is there still an objection to the garnishment?
I mean, yeah, they came in, the original time we came in, they said that I didn't pay anything.
Right.
And they were garnishing my wages. They took, I think out of one check, they took like $350. I just don't have the money for that. And the fact that they came in and said that I wasn't working with them after they garnished my wages in 2016, there was a 4-year gap. I don't think I should be responsible for the extra $1,000 that they're adding on, since they took that 4 years to come back in.
Ms. Baker?
Well, every judgment in Michigan does accumulate interest, and the defendant still had a unsatisfied judgment in place. However, if she would like to make a request for installment payments in lieu of the garnishment, we would be more than willing to consider that.
So is that, I would think that would be where we're heading, is that we have a collections issue. We don't have a, I don't owe issue. We have.
Right.
Right.
I'm not disagreeing with
Right.
that. So yeah, that's fine. That was what I wanted from the beginning.
Right.
And that was it.
Right. I'm looking to see if there was initially and there's never been a plan set up, Ms. Baker, or I don't see one in the file.
Not to my knowledge, there's been no order for installment payments at any point.
Under my acknowledgement, when they did the garnishment, I thought after that, there was no way to make a payment arrangement. They stopped garnishing my wages in 2016. I was still working with that company. And yeah, it still took them that long to come back at me. So I was just confused.
Well, and that's understandable. That's but let's get you a plan. Yeah, let's get you a plan to see if we can resolve this with a plan. We've got a number now, and we need to work towards resolution of that number. Miss Baker, would you like to meet with Miss Fascino to see? I can put her on an iPad to see if we can come up with a plan, or because right now the objection to the garnishment is, I think there's a way around this, and that's to set up a plan. Okay, that just seems to be the most. But we have to set up a plan that's not gonna put you in a place where you can't pay, but also doesn't take forever. You know,
Right,
I mean,
right.
it doesn't do you any good if it takes you 40 years to get all this paid.
Yeah.
So Ms. Baker, did you want to meet with Ms. Fascino to see if there's a plan, if there's one that can be set in place?
I have no objection to that, but maybe she has a number right now she could present to the court and I could let you know.
Do you have?
It's the same number that I presented before, which was $100. That'd be $50 out of each check. If I get more hours, because I've lost clients
Right.
because I can't be at my client at 8 o'clock if I have to be here.
So it would be $100 every paycheck.
$100 every month
Every
until
month.
I can get established and get back to where I was,
Wait, so
if that's possible.
her idea for a plan is $100 a month. We could do it like at $100 for the first year, I would say, and then raise it from then.
I'm agreeable with that.
Yeah, and then I think we go up from then once you're more established. But I guess so it'd be $100 for a year and then back to the normal rates. That would do away with the order to objection to garnishment. That would set a plan in place. The only thing is, after a year, I think it goes back to the normal rate.
That's what I was gonna ask. If there's a possibility that I can make a more amounts, can I contact
You
them?
can always contact Ms. Baker,
Okay,
yes,
okay.
or whatever representative is. But I would think that as $100 a month for a year, and then the traditional structure, whatever is set out for. And in the meantime, you stay in contact with Ms. Baker.
Yeah.
And do you want to write something up, Ms. Baker, and have Ms. Fascino review it for that? I would think it'd be $100 a month for a year, and then the traditional installment plan that raises that amount would go from there. You probably need a number, Ms. Baker, or I don't know what I don't know after $1,200 a month, what would be a traditional number for you in this? I'm kind of guessing at this.
Yeah, I think we'd like at least 200 a month after that.
All right. So $100 for the first year and $200 a month after that.
Can it be split in between 2 checks? Because last time you guys took $300 out of my first
Yeah.
check, and I was just.
So it could be, and if Ms. Baker, you can write that up. And Ms. Fascino can review it, then submit it to the court, and I'll sign it. it'll be due upon, the court speaks through its orders, so it has to be, it'll be once I sign it.
Okay,
But I do think that that's probably the start is $100 a year, $100 a month for a year, and then $200 after that. And that as a way of resigning the debt.
And I just need to know when she can start the first payment.
Perfect.
my check, I think is this Friday. I get paid this Friday.
So,
So I'll return to my payroll today when I get out of here, and it'll be, I believe they already have something set up. Taking.
so Ms. Baker, how about the end of the $100 by the end of the month?
That's fine.
So I'll put it, so the first payment is made by July 28th. That'll be $100 a month. That'll be for 12 months. And then after that, it's $200 a month. And that'll be for the remainder of the debt. That's how I'm, is that how you have it, Ms. Baker?
Yes.
All right.
Would you like that submitted under the 7-day rule then, Your Honor?
Yeah, and so what they'll do is submit it under the 7-day rule. You'll take a look at it, and then if you have any questions, but that's the plan, $100 a month and then $200 after that.
We'll get that prepared, Your Honor.
7-day rule. All right, and that, so I will go ahead and indicate that we've made a plan, and the objections, the objection, once we got a plan, I'll go ahead and indicate that I'm denying the objection to order of garnishment, only because we've set up a plan here, okay? And we got a number, and part of the number was just making sure everybody agreed on the number that we've got. Anything else for the record in docket 1202493, Ms. Fascino? Do you have any questions of me? All right, Ms. Baker?
Just one question. Did you want that
Sure.
taken off your paycheck directly, Ms. Casino, or do you want to make those payments voluntarily?
Can I make those payments voluntarily?
As long as you
Yeah,
maintain
you-
that.
And will it be every day, and will it be on the 28th of each month, or?
Yeah, we'll make it on the, do you want to make it on the 28th or the last Friday of each month then?
Last Friday is fine.
Okay. So last Friday of each month, and plaintiff to make out of, so that'll be made out of the garnishment. That'll be just be made by you to, okay.
To them, correct?
Correct.
Yes, thank you.
All right, I'm going to indicate that we had a hearing today, for lack of a better term. The objections, I'm going to indicate the objections were valid. So we're not going to be garnishing the wages. It's going to just be made, but I'm going to indicate that a plan was set up. All right. All right, Ms. Baker, anything else for the record in 1202493?
Nothing further, Your Honor. Thank you for your time.
All right, thank you. You're all set. Thank you for your appearance, Ms. Fascino.
Thank you so much. Have a good day.
You too. Mr. Burnett, are you here on LAFCU versus Angeletta Woods?
Yes, Your Honor.
All right. Let's go ahead and call that case. And is there, before we get started, is there an Angeletta Woods in the courtroom or in the Zoom courtroom? Miss Woods? Is there any Angeletta Woods in the physical courtroom? All right. So we're on the record in docket 16-01213. That's LAFCU versus Angeletta Woods. Will the parties please introduce themselves for the record? Mr. Burnett.
Yes, thank you, Your Honor. Good morning. My name is Joe Burnett. I'm filling in for Tim Smith today on behalf of LAFCU.
All right, this is the time set for a pretrial in the matter. And I'm going to indicate that on August 22nd, Ms. Woods, well, I don't see Ms. Woods in the Zoom courtroom. Would the Zoom user please identify yourself, ma'am? You're in the car, just for our labeling purposes. That's you, ma'am, in the car.
My name is Tiffany April Griffin. I'm for another court case.
All right. I was just making sure I knew who was in the Zoom courtroom. Thank you.
Thank you, sir.
All right. And then the defendant would fail to appear on a motion to show cause. Then on May 8th, I have that the parties met in a breakout room. I believe Mr. Smith was here on that day. I can't remember, Mr. Burnett, if you were covering or not. And there was a agreement to set this aside for 60 days and payment would be made in full. So we set it for today's date. And it appeared that Ms. Woods has failed to appear once again. Mr. Burnett, how did you want to proceed?
Kind of part of the plan, Your Honor, was we were receiving an income tax garnishment from the defendant, and then to settle everything, she was going to pay an additional $200. We received the income tax garnishment. We did not receive the $200 from her. I think how I want to proceed today, if it's acceptable to the court, we would just request leave to file a motion to show cause at this point. All right.
So I'll indicate for the record at the pretrial, he failed to appear. This was scheduled for 8:30. It is now 8:58. I'm going to indicate that you were able to get a tax garnishment, but the $200 was still outstanding. Is that correct, Mr. Burnett? Is that what you've indicated?
Yes, Your Honor. She has a total balance of $794, but to settle it, we were going to accept $200. So that was the agreement, and that's what we're looking for.
All right. What we'll do is we'll reissue the show cause for the fail to appear. And you'll do the paperwork on that, Mr. Burnett?
Yes, Your Honor.
Okay, it looks like you did one once before. A motion to show cause will be filed by plaintiff. That was on August 22nd. And then maybe at that show cause proceeding is where some of this discussion took place between Mr. Smith and Miss Woods. But I will sign that show cause when I get it.
Okay, very well. Thank you, Your Honor.
All right. Anything else for the record? 1601213, Mr. Burnett.
I believe that is all. Thank you.
Right. Thank you. You're all set. Is there a representative here from First American Auto? Or Shanice Hobbs? Here's Shanice Hobbs. Ms. Hobbs, do you want to come forward here? All right, you can have a seat, ma'am. This is a reset from June 12th. So I'll call to the record, and I have a Jason Michael Katz on it. I'll call to the record docket 2201123. And is there a Jason Michael Katz or a representative of First American Auto in the Zoom courtroom? Is there anybody in the physical courtroom by that? And ma'am, you are Shanice Hobbs? All right. This was a reset for an objection to instruments for notice to be sent to 417 Mifflin Avenue. We reset it so you get proper notice on this because there was some question whether you'd received notice, and we reset it for today's date. That was from June 12th. But then I now I don't have Mr. Katz here. First, I didn't have you here. Now I don't have Mr. Katz here. You were the one requesting installment payments, is that correct?
Yeah.
But at this point in time, I see no reason to not grant your motion for installment payments at this time, since we don't have an opposing party. You know,
They took like 1,100 already for garnishment for my taxes.
Okay.
And then they were taking 100 or something out of my checks. So it should be way less than the balance is now. Or
but
was.
have you been in contact with the First American Auto Leasing or anybody representing them?
Just the court.
Just the court? All right. Well, this is based on your motion to installment payments. I don't have any reason not to grant it. All right. We've reset it. I hate to reset it a third time for all the parties to come up. But there's
It take time out of work today.
Yeah. So I'm going to indicate for the record, and I don't have everybody received notice of today's date, which is what we were concerned about last time, that you got notice of this. Because I think the last one went to your Vermont address, and you're on a Mifflin address now. Anyway, this is based on your request, so I'm going to grant your order. To installment payments. I'll sign that to that effect. The defendant must pay the judgment in installments as follows. You asked for $50 a month starting June 1st. Is that correct? All right. Have you made a June 1st payment? Because I know they'll go back and see.
No.
All right.
We were waiting on court.
All right. All right.
I had filed it like a month before.
All right. I've signed the order for installment payments, and you should be all set. Okay. All right. Thank you. Mr. Winters, Mr. Cox, we can call your case.
Okay.
Grab the right file. All right, we're on the record in Meemic Insurance Company versus Tatiana Varela-Baroto and Cynthia Perez-Varela. Will the parties please introduce themselves for the record?
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
And ma'am, you are Tania Varela-Baroto?
Yes.
Okay. And ma'am, you are Cynthia Perez-Varela?
Yes.
All right. This is the time set for a pre-trial in the matter. We reset it. It was set for June 12th originally. All parties met in a breakout room on June 26th. There was a stipulation to set aside default judgment and adjourn pre-trial to today's date of July 17th on both defendants 1 and 2. Is that correct, Mr. Cox?
Yeah, Judge. And at that time, the parties met in the breakout room. The defendants, I think, got an iPad, and we hashed out what I believe were the terms of a settlement agreement. They hadn't agreed fully to it, but I emailed them the settlement agreement back in June and again last week, and didn't get a response or a signed document. So I'm not quite sure where we stand on it.
All right. Were you able to get that settlement agreement?
Yes, I got it. I looked at like over it, and then he advised me to have somebody else with a little bit more knowledge look over it to make sure everything is okay. I just the $23,000 is just like too much. I wouldn't be able to pay that for like another 20 years, especially with $100 a month. Never get, it's just, and I have 2 kids. I don't have support from my oldest. His dad died, so I'm doing everything on my own. And I'm a waitress, so it's kind of hard. I'm trying to get back into school. I can't do anything. I agree that I do need to pay, which I will. I completely agree with that. I just want the price a little bit if I can.
Like I don't know. Mr. Cox might be able to work with you on that.
Yeah,
you know.
I mentioned it to him during the settlement. And he said that unless I pay a big lump sum, I can't get the price.
The debt owed. This sounds like more of a collections issue than anything at this time. Would you agree with that, Mr. Cox?
Yes, Judge. I mean, technically the case remains open and liability hasn't been decided, but I think we're going to be there soon.
Well, Mr. Cox.
Who's there? Who just spoke? Who just spoke? All right. So, Mr. Cox, do you want the opportunity? Would it help to put you in a room again to see? I mean, I don't know what to do here because you're saying you can't pay. Then it just turns into a collections matter, and you don't want a collections matter. So you should have something to say about the agreement, and I think that's what Mr. Cox was trying to do, was trying to set this up so that you'd have something to say in it.
Yeah.
I don't know without a lawyer present in order to how to lower the debt, because the debt is what it is.
Right.
I mean, I can't unilaterally just say, well, you don't owe half the debt.
No,
Have you had the opportunity to see the settlement agreement at all?
Yes. I've looked over it and everything.
What is the amount that you're to pay monthly right now?
$100.
Okay.
Which is doable. It's fine.
Which is doable. You're worried that it's going to take such a long time.
And I can't pay it, or that it's going to take too long.
Yeah. Yeah.
And then I also had a question. I wanted to know, because I'll pay it, like when we agree and everything, I'll pay it, but I don't see why she's like part of it also. Like I feel like maybe it should just fall on me instead of on her also.
Mr. Cox, can you answer the question concerning why there's two on this? Probably because there were two on the
It was her car, but I was driving.
Right. So you're both on the policy.
Well, yeah, the point there, Judge, is the law provides that when an uninsured motor vehicle is operated and causes damage, that an subrogation claim like the one we filed, plaintiff can proceed against both the owner and the driver of the uninsured motor vehicle. The owner, on the theory, the owner was supposed to secure insurance on that. The driver is not supposed to be driving the uninsured vehicle and operated negligently, and there's no insurance to protect the driver from a tort claim. So it is as to both, because both have liability under the law. And, I did ask, I'm sorry, go ahead.
Go ahead, Mr. Cox.
I was just I did suggest, as I do with every defendant when they're unrepresented, if they want to have someone take a look at the documents, if they have, someone that they trust or an attorney. But there's no requirement that if the defendants are satisfied, at this point, they don't seem to be. But one of the holdups they seemed to suggest was they needed to show the paperwork to someone, and that's fine, but I didn't make that a requirement that they do that. I just suggested, as I always do, because they're not represented, to someone they want to show the papers to. It makes sense to me to do that. And my hope would be that because we're emailing back and forth, or that because I emailed the documents, if they had questions, concerns, and so forth, they could email me back, which is my hope. But
you can email back at any time. It sounds like there's an agreement out there.
I do, yes, and I do agree that I do have to pay.
Right.
Understandable. But if I do sign the agreement, I would like her to not be.
I don't know how to make that happen.
Okay.
I don't know how legally, I mean, Mr. Cox would have to agree that would happen. And I don't think that would be wise for him to do since she's part of the original request. Okay.
I can represent that it doesn't matter to plaintiff who makes the payments. In other words, the fact that they're both signing an agreement and they're both liable jointly and severally, potentially, if one party decides to pay on behalf of both parties, my client does not care who makes the payments. It doesn't have to be 50-50 or, it can be 100% one of the two defendants paying all the money. But just that
you could agree to make the payments as a part of the agreement that you're responsible and the other person's just part of that. That sounds like where we're heading, Mr. Cox, is that I guess one person would take on the responsibility of making the payments, although we leave the second person still on as part of the initial litigation, I guess.
Yeah, I think the settlement agreement as worded doesn't specify which of the two defendants is to pay and how much each is to pay. So from plaintiff's perspective, it's a joint payment between the two of them, and one of the two of them could decide to make that payment on behalf of the other, and it wouldn't make a difference because plaintiff would be none the wiser. So from my perspective, as long as we get the $100 monthly, whether it's that if one defendant, the other defendant, or a third party on their behalf, it really makes no difference.
Right. But there seems to be an agreement out there. It seems to be, I can't reduce it. Okay. Not without something that tells me legally how I'm supposed to. And there's nothing there. Okay. When I looked at it, I had a feeling this was going to happen, but do you need, for today's date, I think that's why we revisited it, to make sure that this agreement, you had time to look at it, you had time to see it, to have anybody look at it. It is a high number. There's no doubt about that the high number. And maybe after a year, you're in a better place to attack that number. But this $100 a month is that's probably the extent for right now that I can see, and Mr. Cox is willing to go there. So, and you've indicated you don't want this to be a collections default issue or anything like that. That's not helpful. Did you want to take a look at this and get back with Mr. Cox? It seems like there's an agreement made. It's just a matter of.
If we can't lower the price, I'll just sign the agreement so we don't have to keep coming back and forth.
So Mr. Cox, it appears that the agreement's going to be is going to be the initial agreement that was sent to you, right? All right, and you'll make certain that that's signed and got back.
Yes.
All right. So it sounds like that initial agreement is the one that we're working on. I'm gonna indicate that the parties met through the court and revisited the agreement, and then I'm gonna wait for the agreement to be presented.
Do we sign it and bring it back here? Do we?
You should be able just to return it to Mr. Cox. Is that correct, Mr. Cox?
Yeah, Judge. I mean, preferably I'd have them either fax or email it back to me, but if they can't manage that, they could also pop it in the mail to the address that's on the agreement. So any of the three ways to get it back to me. I then sign the dismissal and the settlement agreement, file it with the court. The case is conditional while they pay, and then they get copies of those agreements signed by the court in the mail for both of them.
All right. I'm going to indicate that all parties met on the record. The agreement, initial agreement, appears to be what will be signed and submitted to the court.
And I would say if they have any further questions they can email me, and that'd be the easiest way to communicate with me. I emailed them both. I think I emailed both of them the agreement, and both need to sign.
So if you have any questions concerning that, you can get back to them. I'll just wait for the order to come through. All right.
Okay.
And you should be all set. Okay. All right. Anything else on the record? 2300181, Mr. Cox?
No, Your Honor.
All right. I'm gonna make sure I get your names correct. It's Varela-Baroto or Miss Varela. Either, any questions? Okay. All right. Thank you for your appearance today. You're all set.
Thank you, Judge.
And then Mr. Groan, you're here on Resurgent Receivables,
That's correct, Your Honor.
and that's Joel Smith. Mr. Smith, you can come up here. So we're on the record in docket 23-00190. That's Resurgent Receivables versus Joel Smith. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff Resurgent Receivables.
And sir, you are Joel Smith, is that correct?
Joel C. Smith, there's more than one Joel Smith.
All right, I have a letter indicating that you dispute this. We're at the pretrial stage of this, okay? Your letter indicated that you dispute this because you're not the person who opened the account.
I never resided at that address.
Ms. Groan, do you have any information to that effect?
Well, the address he cited, the Edison Avenue address, is just an address we were attempting to serve him. The actual address on the statements is the 1501 Center Street address in Lansing. So I believe that's the address that he claims he does reside at. I do have, this morning I did made a copy of the chain of title. I've made a copy of all the credit card statements along with the credit card agreement that I will mail out to Mr. Smith today at that 1501 Center Street address. I'm hoping he can take a look at it once he receives it, and then we can kind of proceed from there.
Does that?
Your Honor, I requested this information on May 15th.
Right.
So I don't think they presented the evidence in a timely fashion.
Well, I mean, this is a pretrial. I mean, and we can always adjourn the pretrial for, I mean, they just want to make sure they have the right person. And
I don't think.
And you're indicating you're not the right person?
I've never resided at that address, and I'd like to know what address this originated from. If they're trying to serve me at an address that I never resided, what was the address that the credit company?
I just told you it's 1501 Center Street.
Yeah, the original address was 1501 Center Street.
Then why wasn't I? Where did they come up with this Edison Avenue?
Would you like to meet with Mr. Would you like to Mr. Groen? I'm not sure how they came up with that address. This is a pre-trial to see if you can work out some of these issues rather than set it for trial.
To work out the issue is
I think there's an issue to work out.
Discovery has not been open until now. That is the reason why we did not send anything to you prior to this date. We wait to the pre-trial for the court to open discovery. I am more than willing to send the information to you.
So is that information that's being sent to you? Is that you've got the address of 815 Edison Avenue? That was the noticed address.
What address does he reside at?
Yeah. What address do you want to get the information at?
My office is at 1501 Center Street, Lansing, 48906. But I'm asking, where did the original credit card originate from? What ad?
I think this information will provide that. That's what the pre-trial's for.
I don't see why they couldn't have provided that for now.
Because they don't provide it before the pre-trial, because that's when discovery starts.
I'm making a motion to dismiss.
Well, and I'm denying that motion. Okay. So Mr. Groen, what address? So Mr. Smith, what address?
That's the address we were going to send it to, the 1501 Center Street. So we should be all set.
I got a feeling that this case is, did you want to wait to fill out the pretrial statement? We can adjourn it 30 days and make sure he gets all the information before we do that. That seems like a better idea. So you have information before you go into the pretrial. So you have everything you need. But I think it'd probably be a good idea to adjourn the pretrial because it seems a little early in the time period to be signing this pretrial statement out without a date. We should do that on the record. Would you agree, Mr. Groen?
I think he should, I'll ballot today, so 30 days from
Right.
now, he should have received and had an opportunity to review, and I think both parties will be at a better position to
All right.
hopefully talk about this matter.
It just seems that with when you get the discovery and you understand it, then we'll set the pretrial up, and then we'll have a little bit more information once you get it. And you, even if you want to talk to Mr. Groen about this, it's up to you. But I'm going to say all parties appeared for pretrial. Information is to be sent to defendant. And I'm going to reset this. Do I reset this or the civil? So August 21st at 8:30. And that'll be noticed out by the court, and you can receive a notice from my court officer. He'll give it in writing. But let's once some information shared and we know where we're going here, let's reset it for August 21st at 8:30.
Sounds good, Your Honor. I appreciate it.
All right, thank you. Anything else for the record in docket 23-00190, Mr. Groen?
I think that covers it, Your Honor. Appreciate it.
All right. You should be all set, Mr. Smith, and you should be getting information on all
Thank
this,
you.
all
I
right?
appreciate your
All right,
efforts.
thank you.
Enjoy your day.
All right, and then we have docket 23. We'll get through some of the civil stuff and then we can start on. So we're on the record in docket 23-00514. That's Capital One versus Michael King.
Yes, sir.
Good morning, Your Honor. Michael
All right.
Heider for the plaintiff, P75722. How are you?
All right, and sir, you are Michael King?
Yes, sir.
All right. This is the time set for a motion for summary disposition. This was originally came as a pretrial, and the discovery sheet was filled out. And then that was filed by yourself. Well, that was filed by Jeffrey Werber. Are you, and you're appearing for Mr. Werber today?
Yes, Your Honor. Mr. Werber works at my office. We're both from Weber and
Okay.
Olson's.
All right, so I've had the opportunity to look at your motion. Mr. King, did you get a copy of the motion?
Yes.
All right. It's essentially there's no, the motion is that there's no legal motion or no legal issue of fact here. It's a motion for summary disposition. Mr. Kirchenheider, you may proceed on your motion.
Thank you, Your Honor. Yes, it is a plaintiff's motion for summary disposition. It's a C9, C10 motion. We've provided statements showing charges as well as payments on the account. Those statements were sent to defendant's address. There's been, we don't believe there's an issue of fact. We've provided an affidavit as the amount due and owing, as well as the terms and conditions. There's been no response to the motion as required by court rule. So I don't believe there's an issue of fact, and plaintiff has met its burden and is entitled to a judgment.
Thank you. Mr. King, you provided no response on the motion for summary disposition?
Yes, I have not used no cards or nothing like that. No, nothing. So I don't have no information of what they're talking about.
Did you put that in writing or anything?
No.
And we held a pretrial on this matter, and you filled out the pretrial sheet on it, didn't you?
No. I don't understand what he's talking about because I didn't apply for nothing with Capital One, nothing like that.
This is what you got. Show me.
This is all I have for Capital, the pretrial.
Did you file? Did you file a police report concerning an identity theft?
Yes, I did.
Okay, and did you provide any of that information to? I have here a letter indicating that, and this is on April 25th. that you did not file the capital, that this was not yours, but then I also have here that you filled out a pretrial statement.
Pre-trial statement. What did it?
I don't know, does that was on May 22nd. Maybe that note doesn't belong in the file.
Judge, there was a pretrial statement that I believe was done on the record and signed by, entered by the court at the pretrial hearing. I believe at that.
That's what I thought.
Yeah, according to my notes, it indicated that plaintiff would be filing a motion for summary disposition and that a response would need to be filed. Defendant's answer, while it does indicate he believes this is identity theft, nothing has been provided. We have not received a copy of any police report. My client has reviewed this as a fraud issue. Again, the billing statements went to defendant's address, and there were payments made on those statements for months, as well as transactions and recurring transactions. While I can understand defendant's claim, I do believe plaintiff has met its burden.
All right, Mr. King, have you provided any? I don't have any information to indicate that this is a lack of identity. I've got no information indicating any police report that was made. The pretrial statement's already filled out, so it's not like you haven't had time to provide that information. How do you explain that?
Hey, best thing I can say is I just didn't know what to do about that and stuff like that. I just didn't know. I went through surgery and stuff like that, and I've been through a hip surgery, and I couldn't move around like I wanted to, and I just didn't have the opportunity to do what I have supposed to do, but I just didn't use them cards and stuff like that.
That's not a defense, and you didn't file a response to the motion, and their payments were made on the card.
Well, it wasn't made by me.
Well, I don't know who else would make the payments, Mr. King.
Wasn't made by me though. That's all I'm saying. It wasn't made by me.
All right, I'm gonna grant your motion for summary disposition, Mr. Kirchenheider.
Thank you, Your Honor. I'll prepare an order.
All right.
Thank you, Judge.
Anything else for the record in docket 230514?
Not this time.
Mr. Kirchenheider.
Not this time.
Mr. King, you're all set. Thank you for your appearance today.
What you supposed to do?
Well, I granted the motion for summary disposition, so you're responsible for the debt.
Oh, wow. So when he come to court, he ain't got to come to court on the 27th of September?
It's now a collections issue, ma'am.
Mike, you got to pay it, he said.
Okay, so it's now a collections issue.
So
but I granted the motion for summary disposition.
This is crazy. Okay. Okay, thank you.
Thank you, ma'am.
That's crazy. You got to pay for what that girl did to you. You should file the police.
Mr. Wobu, you here on a case?
Yes, sir.
So you can come up here. So Mr. Wobu, this is we're on the record in docket 23-00696. That is Christian Wobu versus Sarah Hoffman. And Mr. Wobu, you're here. This is a motion to set aside the conviction, I believe. Is that correct?
Yes, Your Honor, I want to do the order of eviction and I noticed the time that is fine.
Oh, it was past 56 days?
Yes, yes. Judgments have been given.
Yeah, there was, so Ms. Hoffman is not in possession.
Yeah, I think
But this was initially, it was a defendant failed to appear on April 19th.
yes.
On May 1st, it was the second hearing that where the defendant once again failed to appear.
Yes.
But then we didn't receive any paperwork. And it's got to be filed within 56 days.
Yes, I think I submitted the paper. I just I wanted to file for the order of eviction after the judgment was made. I believe the judgment had been granted.
Looks like you. This looks like you requested a money judgment and there was no.
My concern just to
Yeah, there was no money judgment. You didn't pay fee. Yeah.
just my concern, just position.
So I'm confused. So what are you requesting today?
Just for possession.
And where's Miss Hoffman today?
She didn't show up.
But that's her third time she didn't show up.
Yes.
Yeah. But why wasn't the first, why didn't, so the May 1st order that I signed that wasn't followed up on? Why?
Because of the time, we have a lot of other things.
Oh.
So before I know it escaped my mind.
So do we have a form for a default, another one? I can grant your motion, set aside and reissue the order that I sent for May 1st. I just don't know if that's going to make the landlord tenant department. This is one where we redid the order because you asked for a money judgment and you hadn't paid for a money judgment. So we blanked that all out.
Okay, so I don't care for a money judgment.
Right. You just want, and it has on it, the plaintiff has the right to recover possession of the property.
Yes.
But then that was signed on May 1st.
Yes. So I went to fill in the order of eviction. It was expired there. Before I think it's expired.
Well, if we don't do something today for you, it won't get done. So. All right, well, let's try it again. Let's try it again. I'm going to give you an order to give to them this time, okay? And I'm going to make sure that it's filled out here on the record. So we have a default judgment. The plaintiff has a right to recover possession. There's no money in regards to that. I'm going to make I've got to make it'll be 10 days from today's date again. So July 17th, 1, 2, 3, 4, 5, 6. I got the 26th, is that right? 27th. All right. I'm going to check 4B that the plaintiff can apply for an order evicting the defendant if the defendant does not move out on or before the 27th, okay?
Yes, sir.
Because payment's not an option here. I'm gonna check box 5 for maybe liable for money damages. Partial payment will not suffice. And no money judgment is entered at this time. So with this in hand in the file, I'm granting your motion, okay? Mostly because I've never seen Miss Hoffman before. She's never showed up. So I think she was given notice of this. So the motion to set aside is granted. And new orders in the file. And you probably want a copy of this, all right? This will be in the file, the original, but I'll give you a copy, okay? Anything else, Mr. Wobu, on docket 23-00696?
No,
you're all set, sir. Thank you.
Do I need something to pick up or shall I go?
He'll give you a copy of the order.
Okay, thank you.
Then Ms. Mannon will call your case. You are the last of the civil matters.
Thank you, Your Honor.
All right, so we're on the record in docket 23-01186. That's Marwan Hayden versus Tiffany Griffin. Will the parties please introduce themselves for the record?
Cindy Mannon, covering for Robert Akanicki. My P number is 34937.
All right. And ma'am, you are Tiffany April Griffin?
That's correct, sir.
All right, this is the time set for a pre-trial in the matter. Ms. Mannon, I know you're covering for Mr. Akanicki. Have you had the opportunity to meet with Ms. Griffin to discuss some of these issues?
No, Your Honor, I don't. I just have an email from Mr. Akanicki telling me what he would like in the pretrial statement.
All right.
Asked.
So, Ms. Griffin, what we'll do is I'll go ahead and fill out the pretrial statement. We have a pretrial statement in the file right here.
Okay.
And I'm gonna and we'll set up some of our discovery issues and things of that nature for an exchange in information.
Okay.
So I can do that on the record here, and that way, and then with your permission.
Yes, sir.
All right. So I'll indicate that Cindy Mannon and Robert Akanicki are here for the plaintiff, and Tiffany Griffin is here for the defense. Pretrial conference was held on today's date. So my first box, and I know this is early in the game for the pretrial statement, but Ms. Mannon, do you have, this looks like a termination of tenancy, is that correct?
Yes, Your Honor, it's a termination of tenancy, but for damages beyond damages beyond security deposits, stolen appliances, and unpaid rent. Mr. Akanicki says the defendant denies all damages. There's no legal issues.
So termination of tenancy is and damages are the result of the lawsuit. And Ms. Griffin, you wouldn't disagree with that? That was the nature of the filing of the complaint. Not whether it has, I know you're disputing it, just that was the nature of the filing of the complaint, was damages after termination of tenancy.
Yes, sir.
All right. And then the pleadings were the complaint. Was there a response to the complaint, Ms. Griffin?
Yes, sir. I sent in a letter in June with my proof of my insurance that submitted the payment. They submitted $15,000 to the landlord, and I submitted the receipts from the auto owner's insurance and a letter documenting what those receipts were.
So, response and receipts from the defendant. Do you expect any motions, Ms. Mannon?
No, Your Honor, no 2116 motions is what I have.
So no 2116 motions?
Yes, sir, no.
All
None.
right. Ms. Griffin, do you expect any motion for summary disposition or anything along those lines?
What, I'm sorry, sir, but what does that mean, please?
That would mean that what you'd be saying is there's no issue of, there's no legal issue here in the complaint.
No, there's no legal issue.
All right. But then you'd be filing you'd be indicating there's no legal issue in the complaint. That's what a motion for summary disposition would be. So you'd be indicating that you're not responsible or they got the wrong person, something along those lines.
Yes, sir.
You'd have to file that motion. Do you understand that, ma'am?
Okay, I can do that.
So that motion was discussed. Summary dispo. I'm going to indicate no for consolidation. Is that correct, Ms. Mannon?
Yes, Your Honor.
I think that's too early in the discovery process for admissions of fact, any other than anything in writing or any exhibits. Would you agree with that, Ms. Mannon?
Yes, Your Honor.
Ms. Griffin, you'd agree with that? It's still too early. We haven't had any discovery, so I can leave that as too early at this time.
The landlord is suing for $12,000. I submitted proof that the insurance paid him $15,000. So and also proof that the rent was paid during that time, and they sent additional money besides the security deposit. I don't know if you received the letter, sir, with that.
I did receive the letter. I'm treating it as a response along with any receipts or anything that's been made, anything that was made to the plaintiff in this matter, which is Mr. Akanicki's, it's Marwan Hayden is the plaintiff in the matter.
Okay.
Ms. Mannon, I'm gonna set discovery for 90 days. Do you think it'll go beyond that?
No, Your Honor, that's fine. Thank you.
Okay, discovery. So the cutoff date for discovery would be July, August, September, October 17th. That'd be a Tuesday. Neither party has filed so I placed too early on expert witnesses without more discovery, damage or joinder of claims. Has either party filed for a jury trial at this time, Ms. Mannon?
No, Mr. Akanicki wants no jury.
All right. Ms. Griffin, if you filed for a jury, you'd have to pay an amount for a jury trial. That fee has to be paid. I don't think there's been a fee paid at this point. Is that correct?
Sir. Yes, sir.
All right. So if you change your mind, that's always available, but you'd have to pay the fee for that. All right.
Yes, sir.
I'm going to indicate that the possibility for settlement at this point is too early. Is this Ms. Mannon, are you looking for any type of mediation in this case?
Mr. Akanicki says no case evaluation, mediation if the defendant agrees.
So Ms. Griffin, would you be amenable to setting this for mediation concerning some of the legal issues here and having an outside party look at it, other than the court?
So does that mean like that I have to contact the insurance and have their lawyer come and show proof of what they did? I'm sorry, I'm confused. I apologize.
You'd be able to show whatever documents you might have to a mediator. Then
Okay.
they would try to see what legal issues are here that need to go forward, or if this is something that can be worked out.
Okay, yes, sir, that's fine. Thank you, sir.
All right. All right, Ms. Mannon, do I have your permission to sign this on your behalf?
Yes, Your Honor, thank you.
Permission to sign is granted. And then Miss Griffin, all I've indicated is what we've talked about on the record. I've indicated the issues of the complaint, some of the pleadings, and that you responded with some documents. We put October date, October 17th, as an in for discovery. That can always be addressed later. There may be motions for disposition. And then I placed that some of these expert witnesses damages, it's too early without more discovery, and that this would be a case for mediation for mediation to look at. With that understanding, do I have your authorization to sign this on your behalf?
Yes, sir.
Okay. All right, I'll go ahead and sign the document. You'll both get a copy of the pretrial statement. I'm going to indicate that the pretrial was held. And pretrial statement completed. All right, anything else for the record, docket 23-01186, Miss Mannon?
No, Your Honor, thank you.
Miss Griffin, you should be all set. If this goes to mediation, you'll be contacted by mediation concerning what time and when.
Okay.
But in the meantime, if you have any questions, make sure and contact Mr. Akanicki, okay?
Yes, sir. Thank you.
All right, thank you. You're all set.
God bless.
Thank you, sir.
Thanks. All right, Amani, did you want me to start calling some cases here? Those are our 8:30s.
Yeah,
Our
I think
civil.
Lauren will be covering the whole docket. Erin had to go. She had a hearing in front of Kennedy.
All right, and I'm admitting some, I don't know who's on the fire tablet.
I think she's with someone.
Okay.
This is Tom Sheehan.
All right, sir, on the cell phone, would you please identify yourself?
Thomas Casimir Sheehan, SHEEHAN, 33062. I'm not sure if I got dropped. This technology has me beaten.
All right, Mr. Sheehan, you're in the right place. You're both, Mr. Sheehan and Ms. Solis, you're represented by the public defender also, right?
He never did call me.
Hang tight, we have a public defender here, okay?
Yeah.
So, so you're in the right place, okay?
Okay.
All right.
I'm an engineer. This is embarrassing.
Miss Reed, you're here for your 9 o'clock also?
Yes, sir.
All right. What about Miss Lewis? Mr. Foreman, are you represented by the public defender today?
Yes, Your Honor.
All right.
Yeah, that's, I do not have anybody.
Okay. I don't have anybody of record either, but Ms. Brzezinski, what case are you here on?
South Washington Park Apartments.
South Washington Park. Okay, that's set for 10 o'clock.
Yes,
And you're the property manager?
yes.
All right. We've got a few cases in front of you, but we'll start going on those in a little bit.
No worries.
Some bitch. Oh, oop. Sorry.
So we'll go ahead and call that. So we're on the record in, I've got two files.
I believe that's correct, Your Honor.
I got three. No, I got two. Oh, three.
Yeah, three.
I got three files.
Okay, I was gonna say.
Yeah.
Maybe I lost one along the way.
No. All right. So we're on the record in docket 21-01773. Make sure I got these. 21-02635 and 22-02237. That is the City of Lansing versus Remy Lewis. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Thomas McKee on behalf of the city requesting permission to practice under MCR 8.120.
And that permission's granted. Ms. Sutter.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Lewis, who I do not believe is present.
Now, this is the time set for, this was initially set for 8:30. It is now 9:59 after we got through all the civil stuff. I do not see a Mr. Lewis in the Zoom courtroom. I don't see a Mr. Lewis in the physical courtroom. It would appear that Mr. Lewis failed to appear for the final pretrial on all three files. Mr. McKee, how did you want to proceed today?
City would request a bench warrant bond forfeiture and a 48-hour.
Ms. Sutter.
Just request the 48-hour hold, Your
All
Honor.
right. So bench warrant with a bond forfeiture. I'm going to indicate D failed to appear. Bench warrant, bond forfeiture. Due to the nature of the offenses, we'll do a 48-hour hold. I don't have a previous fail to appear. So that's all for the record in 21-01773. That's all in 22-02237. And that's all in 21-02635. Did you want to go on Miss Dukes next?
Yes. You can, Your Honor, yes.
I've got Miss Duke for. Oh, that's the show cause. All right. Let's do the pre-trial. So we're on the record in docket 23-01584. That is City of Lansing versus Ariana Duke. I also have a companion, a second show cause file, but let's go on the pre-trial first to hinder oppose. Parties appearances for the record.
Thank you, Your Honor. Thomas McKee on behalf of the City of Lansing practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter appearing on behalf of Ms. Duke, who joins us via Zoom.
And ma'am, you are Ariana Duke?
Yes, I am.
Thank you. This is the time set for a pre-trial on the City of Lansing case. Mr. McKee, how are we proceeding?
Your Honor, it's my understanding that Ms. Duke will be pleading to the charge with a Killebrew agreement for time served.
And is that your understanding, Ms. Sutter?
It is.
So she'd be pleading under the city code of, it's the hinder oppose, it's 90 days and or $500 are the potential consequences. There's a Killebrew agreement of jail time served, right?
Correct.
All right. May I inquire of your client of their misdemeanor advice of rights?
Yes, Your Honor.
All right. So Ms. Duke, you understand that the maximum penalty in this matter is 90 days and or $500 pursuant to the City of Lansing Code of 602.02. There is a Killebrew agreement of time served in this matter. If I was to follow that Killebrew agreement, if I refuse to follow that Killebrew agreement, you could withdraw your plea. Do you understand that, Ms. Duke?
Sir.
Okay. Is that a yes? I'm sorry you broke up there.
Yes, sir, it is.
All right, thank you. So I'm going to read to you, you have certain rights in this misdemeanor plea, and I'm going to read those rights to you. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses brought against you. You, of course, are represented by public defender Lauren Sutter. She would be present to contest any charges or cross-examine any witnesses brought against you at trial. Do you understand that, ma'am?
Yes, I do.
Okay, you have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than the stated plea agreement and Killebrew agreement, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal any trial. Since you won't have a trial, there'll be nothing to appeal. Do you understand that, ma'am?
Yes, sir.
And it's my understanding that it's your wish to waive those rights and plead guilty to count one of the City of Lansing summons and complaint. Is that correct?
Yes.
All right. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay. And it is indicated that on 5500 K North, Lansing, City of Lansing, Ingham County, that you did at that time on November 10th, 2022. Were you in the City of Lansing at that K North address on November 10th, 2022?
Yes, I was.
And was there a Lansing police officer in uniform providing you with either an order that you hindered, opposed, obstruct, or resisted?
Yes.
Why don't you tell me what happened, Ms. Duke?
I was getting detained for those previous charges. And basically when the officer just tried to detain me, my kids are crying, so I just kind of tried to reach for them during the time of detainment because my kids are crying.
All right.
So
you knew that he was a police. You knew he was a police officer at the time?
Yes.
All right. I find the plea to be understanding, voluntarily, and accurately made. Any questions, Mr. McKee?
City satisfied with the factual basis.
Ms. Sutter?
No further questions.
All right. I find the factual basis to be no understanding, voluntarily, and accurately made. I'll follow the Killebrew agreement of time served. And if we can do this, we can put this with its collections or with that, and let's see if we can put it all together so we can do both. So, Ms. Duke, you're gonna have fines and costs, $75 for a state fee, $75 crime victims' rights fee, $50 for a state fee. That's $125. I'm gonna assess a $200 fine, so that'll be $325. If we add that to your outstanding $150, let me get you a sum total here. So I think that would be $475. $325 plus $150. And $150 is on the no insurance show cause that's outstanding right now of $150.
Sorry about that light back.
I'm supposed to pay that? I thought that was put into collections with the other ones, with other things, so I can make it on the payment
Let me
plan.
check, because if that's the case, then let's put them all together.
Okay.
So you think it's already been added to your collections?
Yeah, because when we had the other show calls, they were supposed to put both of the files together because I knew I was supposed to pay. So Flores, the judge said that he was just going to put everything together for me. And then I went and made another payment plan. We went and made another payment plan after the court hearing.
Okay. We're checking on it, Ms.
Yeah,
We'll check.
Let me check, see what the computer has.
This was not put in the car.
Let's put in collections. So let's show cost for 150 is referred to collections. That'll take care of that file. And then we'll refer this to collections, this outstanding balance.
So she's going back into collection.
Yeah. Right. So So Ms. Duke, the initial 150 for whatever reason was not put in the computer in collections. And but we put it in collections now. We have also the 325 out of the city of Lansing file. That's also been referred to collections. But what you'll have to do is you'll have to come back and fill out some paperwork to make sure they have everything, okay?
Yes, sir.
All right. So yeah, because that adds a 475 balance to your collections. And so you want to make sure that so that you're not caught up in a show cause cycle, that you get there and make a determination as to what you need to pay and fill out any more paperwork they have, all right?
Okay, I understand.
All right. Anything else on the record in 23-01584? And we looks like 21-02-115, but for our purposes, 1584, Mr. McKee.
Nothing further, Your Honor.
Ms. Sutter?
Nothing further, thank you.
All right, Ms. Duke, you should be all set. Go to collections just to make sure you're on the same page with them, but you should be all set, ma'am, okay? All right.
Okay, thank you. Thank you.
Want to go ahead and, so you tell me what. So we're on the record in docket 23-01129. That's the city of Lansing versus Markeisha Reed. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing under MCR 8.120.
Good morning, Your Honor. Sorry.
Go ahead.
Assistant Public Defender Lauren Sutter appearing on behalf of Ms. Reed today, who joins us via Zoom.
And ma'am, you are Markeisha Reed? And you'll have to unmute yourself, ma'am.
Yes, I am, sir.
All right. So you are Markeisha Reed, is that correct?
Yes, sir.
All right, this is the time set for a City of Lansing pretrial. Mr. McKee, how are we proceeding?
It's fine. We would be requesting an adjournment, Your Honor, 45 days if possible, due to the conditions of our agreement with defendant having been modified.
Is this a compliance issue?
It is, Your Honor. She was asked to
Your
complete some
Honor,
community service.
Community service,
Service.
and we changed the terms for that, so she's we're requesting to give her more time so she can comply with the new request.
All right. So let's do 6 weeks. We'll do 6 weeks.
Thank you, Your Honor. We don't.
All right, we'll do 5 weeks. What's the date?
August 21st.
August 21st. At 9. All right, so Ms. Reed, we've adjourned this case for compliance issues to August 21st at 9 o'clock, okay?
Okay, sir.
All right. Anything else for the record? 23-01129, Mr. McKee.
No, Your Honor.
Ms. Sutter?
No, Your Honor, thank you.
All right. That's all for the record in that file. Ms. Reed, please keep in contact with your attorney, Ms. Sutter, and we'll see you on that date. All right, ma'am?
Okay, thank you.
We can just finish up everyone on Zoom, I think.
Perfect. All right, so we're on the record in docket 23-01944. That is the city of Lansing versus Logan Foreman. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the city of Lansing, practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Foreman, who joins us via Zoom.
And sir, you are Logan Foreman?
Yes, Your Honor.
All right, this is the time set for a city of Lansing pretrial. Mr. McKee, how are we proceeding today?
The city would be requesting a 60-day adjournment for compliance purposes, Your Honor.
And that's your understanding, Ms. Sutter?
It is, Your Honor.
This is the first, it was arraigned on June 22nd, and how far out is that 5-week date for that, the other one? You one you just gave?
It's 5 weeks.
Yeah, let's do that one.
8/21 at 9.
So 8/21, I can do, let's start with 8/21 at 9.
And I want to note for the record, I am concerned about that date. We're having issues scheduling timely meetings with substance abuse centers, which is what's at
Right.
issue here. They're quite backed up.
All
this
right,
summer.
just let us know. I'm only picking that date because I know that the end of August is kind of hit or miss for the court. Because I know that there's a judges conference there, and then I know that I've got some time off at the end. So let's just, and then we have Labor Day. So I know all those, and that judges conference sets like a whole week on. So let's set it then and then just come back. All right, let's just as a control date. So Mr. Foreman, you're set at August 21st at 9 a.m. just to see where the case is at, and then we'll review it at that time. All right, sir?
Sounds good, Your Honor.
All right. Anything else for the record in docket 23-01944, Mr. McKee?
Nothing further, Your Honor.
Ms. Sutter?
Nothing further.
All right, thank you. That's all for the record. You're all set, Mr. Foreman.
Thank you, Your Honor.
Thank you. All right, did you want to meet with Sheehan?
Oh, this is Mr. Sheehan.
Yeah, what we're gonna end up doing is I'm gonna place you in a breakout room with your public defender so you can talk to her a bit. There's also a couple other people here that she's gonna talk to, and then we'll put your case on the record. All right, sir?
Yes, thanks.
Okay, perfect. Mr. Clerk, you're here for your 10 o'clocks?
Yes, Judge.
I bet you we can put some of those on the record because we're running so far behind. So let me pull those first two. That's 8-9. And 8-9 and 9-1. Are those the two 10 o'clocks?
Yes, Your Honor.
All right. Let me quickly, I don't see anybody, but go ahead and call Brent Decker and Justin Kane. I think they're both going to be failed to appears, but I think these are second hearing set, aren't they? Yeah.
They're in the second hearing slot.
They're in the second hearing slot.
That, you know, we just make up this go.
But with our luck, they show up.
No.
Yeah. Nothing? All right. Thank you, Daniel. All right, so we're on the record in docket 23-01289, South Washington Park versus Brent Decker. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Jeff Klug appearing on behalf of plaintiff South Washington Park.
All right, this is the time set for the second hearing set on a landlord tenant hearing. I have it set for June 21st. That defendant failed to appear. It was serviced by attachment, so we set it for second hearing on this date. It would once again, this was scheduled for 10 o'clock. It is now 10:17. It would appear that the defendant failed to appear a second time for second hearing. And Mr. Klug, did you want to put any, how are we proceeding?
Your Honor, plaintiff would like to move forward with a default judgment against this defendant.
And do you have any numbers you would like to place on the record?
Yes, Your Honor. As of today's date, the rent due and owing is $1,494. Court cost of $162 for a total amount of $1,656. and I will send in a default application and propose default judgment to the court.
All right. To the best of your knowledge, Mr. Deckard's not a minor, incapacitated, or in the military service, and the premises was kept for its intended use?
That's correct, Your Honor.
All right. So the orders to follow on this file. Anything else on this file, 2301-289, Mr. Deckard? I mean, Mr. Klug.
No, Your Honor.
Thank you. And then we'll call to the record docket 2301-291, South Washington Park versus Justin Kane. Parties' appearances for the record.
Good morning, Your Honor. Jeff Klug on behalf of plaintiff South Washington Park.
All right, this is the time set for landlord tenant pretrial. The initial pretrial was set at June 21st. The defendant failed to appear at that hearing. We have service by attachment. It was set for the second hearing today. And it would appear that Mr. Kane, who's not in the Zoom courtroom and is not in the hallway we called, and not in the physical courtroom, has failed to appear. It was scheduled for 10 o'clock. It is now 10:19. And the defendants failed to appear for second hearing. And Mr. Klug, did you want to, I'm assuming you're asking for default judgment in this. Did you want to place any numbers on the record?
Yes, Your Honor. Plaintiff would like requesting default judgment. Rent as of today's date is $2,565. Court cost of $162 for a total amount of $2,727. The premises have been kept fit to reside in. The defendant, to the best of my knowledge, is not in the military, not a minor, and is not incompetent.
Perfect. So the orders to follow to that effect. Anything else for the record in docket 2301-291, Mr. Klug?
No, Your Honor.
All right, that's all for the record, 2301-291. And then we'll call your 10-15 cases in about 10 minutes, all right?
Sounds good, Judge. I'll try and get all those judgments.
All right, thank you.
Thanks.
Mm.
Just credit, I think Mr. Sheehan may have been waiting longer.
So we're on the record in docket 2301-283 and 2301-298. That's the city of Lansing versus Thomas Sheehan. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Thomas McKee on behalf of the city, practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Sheehan, who joins us via Zoom.
And sir, you are Thomas Sheehan?
Yes, sir.
All right, perfect. This is the time set for a pretrial in the matter. Mr. McKee, how are we proceeding?
It's my understanding that the defendant will be admitting responsibility to civil infraction, breach of the peace, and the city will be dismissing the second count trespassing.
All right, so it's the breach of the peace on 283.
Either one of them. Your
Either
Honor,
one.
they're both
We'll make it.
just
We'll do it
charges.
chronologically.
Yes.
Okay.
Oh.
Admit to civil infraction, breach of peace. What's that? What's the civil infraction under?
Would you like the PAT code or the fine?
Either, just the both.
I've got those. It is MCL 750.170. And the fine is $150.
And that's the civil infraction, right?
Correct.
Perfect. And that's your understanding, Mr. McKee?
Yes, Your Honor.
All right. All right. So, Ms. Sutter, you'll be admitting responsibility on behalf of your client?
Yes, Your Honor.
All right. And that's your understanding, Mr. Sheehan, you'll be admitting responsibility to a civil infraction of breach of the peace. With that, the second file, 23-01298, will be dismissed.
Yes, sir.
All right. Just so we're working from the same ticket, Ms. Sutter, this is for April 20th, 2023 at the offense location of Large Street, East Shiawassee. And in that, you're admitting responsibility that your client was in breach of the peace pursuant to 750.10.
Yes, Your Honor.
And that's a fine of $150. So that responsibility is accepted. With that, I'm going to dismiss file 23-01298 as part of plea negotiations. Does your client need some time to make that payment, Ms. Sutter?
Yes, Your Honor. If you could allow him 45 to 60 days to make that payment.
All right. So let's do that same August date. Yeah, just because I know it's there and I know that. So, Mr. Sheehan, I'm going to give you till August 21st to make that $150 payment.
Yep. Yes, sir.
And that can be paid to the city of Lansing online, or you can come to the counter and pay on the 6th floor. All right.
Okay. Thanks.
Anything else on the record in docket 23-01283, Mr. McKee?
No, Your Honor.
Ms. Sutter?
No, Your Honor. Thank you.
All right, so payment to be to the city of Lansing on August 21st, $150, and you're all set, sir, okay?
Thanks. Yes, sir.
All right, thank you.
You.
And then Ms. Solis?
You're free to log off, Mr. Sheehan. Thank you.
Okay, thanks. If I can figure it out.
Okay, you're up. So we're on the record in docket 23 L2765341, that's City of Lansing versus Cynthia Solis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
Good morning. I'm sorry, Your
Go
Honor.
ahead.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Ms. Solis, who is standing to my right.
And ma'am, you are Cynthia Solis?
Yes.
All right. This is the time set for a City of Lansing pretrial. Mr. McKee, how are we proceeding?
It's my understanding that the defendant will be admitting responsibility to an amended charge, civil infraction impeding traffic. That is MCL 257.676B.
What's the fine on that?
$130, Your Honor.
That's your understanding, Ms. Sutter?
It is, Your Honor.
All right. And you'll be accepting responsibility on behalf of your client?
Yes, I will.
All right. And Ms. Solis, that's your understanding. You'll be pleading guilty to the civil infraction of impeding traffic pursuant to 257.676B. That's a $130 fine. All right. So just so once again, we're working from the same ticket. We'll honor about May 14th, 2023 at the offense location of Kavanaugh, East Kavanaugh, Relius Road, City of Lansing. This would be an amended ticket of impeding traffic on the misdemeanor count. Is that correct?
Yes, Your Honor.
That's that failed display of valid license count.
Correct.
Okay. And on that date and time in the City of Lansing, does your client admit to impeding traffic?
I am in responsibility on her behalf.
Thank you. So the payment of $130 is assessed, and does your client need some time to make that payment?
Yes, Your Honor. If you allow her 90 days to make those payments.
So we've got, yeah, give me a date.
October 16th.
October 16th. All right, so so we've extended the date of payment to October 16th, 2023 for the $130 payment. That can be made online or in person, all right, ma'am? All right. Anything else for the record in ticket 23L2765341, Mr. McKee?
Nothing further, Your Honor.
Ms. Sutter?
Nothing further, Your Honor.
All right, ma'am, you're all set.
Thank you. Have a good day.
You too.
Any questions, email us.
Thank you.
I don't think Mr. Williams is here.
No, Your Honor, and I'll be honest, I was never notified that he was picked up on the bench warrant arraignment, so I didn't realize until this morning he was on the docket, so I have made no attempts to contact him. Didn't know to try last week.
Defendant called prior to warrant requested with intent to hold pretrial. So did he call? It's in your writing.
Senior defendant called on 48-hour hold. So he called and he was given a new notice.
Okay,
And that never made its way to my office.
right. But his notice was for today. Okay. So
It
let's,
was sent on 6:30.
on June 30th. Yeah, that's what I have. Defendant called prior to warrant requested. Is that Susie's writing?
Oh, yeah, that's Susie's writing.
It's Susie's writing. Okay. That's what I thought. Yeah. It's that purple pen that throws me.
She does like that purple pen. doesn't
Yeah, she does. Okay, so we're on the record at docket 1901872. That's City of Lansing versus Alvin Williams. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Mr. Williams. I do not believe he is present at this time.
We had, he was set for pre-trial, or this was adjourned for compliance issues for June 26th, and there was a bench warrant set with a 48-hour hold for no previous fail to appear. He called prior to that, within that 48-hour time, to our clerk's office, who gave him notice and set it for pre-trial today, and then he failed to appear today. So with that understanding, Mr. McKee, how did the city want to proceed?
Oh, sorry, Your Honor. Manny Williams, Assistant City Attorney, appearing on behalf of the City of Lansing. So my concern was if he did not receive enough notice, but it looks like that he did receive enough prior notice to appear today, correct?
Correct. That's what he was actually not warranted and given notice for today's date.
Okay.
So that's, and then he failed to appear. So how did you want to proceed today?
And Your Honor, the city is requesting a bench warrant bond forfeiture of 48-hour hold.
Miss Sutter.
48-hour hold request, Your Honor, otherwise no comment.
Look, it's not the crime of the century. It's driving while license suspended. He is, I don't have a problem with the 48-hour hold.
Thank you.
And the last time he did call, he just failed to appear for the next time. So, but he's running out of he's running out of his 48-hour holds, so to speak. That's all for the record. 1901872.
Thank you.
And then Mr. Islas Alcantara. You're not on that one, are you?
We looked that up earlier, Your Honor. I believe he was denied the second
twice.
time. Yep.
All right.
Do you have a date when he was denied this summer by chance?
Well, I have some sketchy things that I've pieced together, and I believe it's June 10th.
We will go with June 10th.
Yeah.
Thank you, ma'am.
He on July 3rd said he was going to apply again.
Right, it looks like we spoke to him at some point on the 6th, and then on June 10th in our scheduling system, there was a note about denial contact.
Okay.
I'm
All
extrapolating
right.
from there.
So we're on the record in docket 21022539 and 21033888. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Thomas McKee on behalf of the City of Lansing, practicing under MCR 8.120.
This is the time set for a pretrial on the matter. Mr. Alcantara is not in the Zoom courtroom. It's not in the physical courtroom. He has been in court before and has been told to get public defender representation or show up. It appears he's done neither today. This goes back to July 3rd for PD representation, and he was denied initially on June 10th of that. Mr. McKee, how are we proceeding?
Your Honor, the city would request a bench warrant bond forfeiture and a 48-hour hold.
Okay, based on the type of offense it is, and no previous, I've got a previous to fail to appear at arraignment, but I treat that a little differently as a fail to appear for the actual pretrial. I'll issue a bench warrant bond forfeiture with a 48-hour hold. I think that's this morning.
Nope.
All right. I'm gonna do some civil stuff.
Oh, that sounds fun. Better
Do
you
some-
than me.
So do I see any of you this afternoon?
Yes, Your Honor, we have sentencing at
Okay,
1:30.
at 1:30. Are you here on Laredo?
Yes.
All right. All right. Ms. Sutter, have a nice day.
Thank you, you too. I'll see you
welcome.
tomorrow.
All right, Ms. Go
Sorry, a
ahead.
quick question on tomorrow. Wendy, so I was talking to George. Did you get the Nolly for Diamond or does George need to send another one?
I got the one you sent me that Bradowitz signed.
Right, from Thursday. Is that sufficient or do you need?
Yeah, that'll work.
Okay, thank you. I don't,
Thanks for checking.
see you next week. Have a
I'll
good
see you.
one. I want to deal with that case as little as humanly possible. Have a good one, folks.
All right, Mr. Klug, we're here on docket 23-01293 South Washington Park versus Cleola Acree. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Jeff Klug appearing on behalf of plaintiff South Washington Park.
All right, this is the time set for the second hearing in this matter. On June 21st, the defendant failed to appear for the first hearing. This was set for second hearing because of service by attachment. That was scheduled for 10:15. It is now 10:44. It would appear that the defendants failed to appear for the second hearing. And Mr. Klug, how would you like to proceed?
Yes, Your Honor. The plaintiff would like to proceed with a default judgment against the defendant. I'd like to place the terms on the record. The rent as of today's date is $4,519. Court costs $162 for a total amount of $4,681. And the premises has been kept fit for the defendant to reside in. To the best of plaintiff's knowledge, the defendant is over the age of 18, is not incompetent, and is not in military service.
Thank you. And the residence was kept for its intended purpose. That's correct?
Correct, Your Honor.
And I'll reiterate, I do not see a Cleola Acree in the Zoom courtroom or in the physical courtroom. So the default judgment is granted. You'll follow that up with an order?
Yes, Your Honor.
All right. All right, anything else on record 23-01293, Mr. Klug?
No, Your Honor.
All right, that's all for the record in that file. And we have on the record docket 23-01294, South Washington Park versus Stiles Wells. Will the parties please introduce themselves for the record?
Yes, Your Honor. Jeff Klug on behalf of plaintiff South Washington Park.
This is the time scheduled for a second hearing. The first hearing was scheduled on June 21st. Defendant failed to appear for that first hearing. So we've set it for second hearing because of service by attachment. I do not see a Stiles Wells in the Zoom courtroom. I will identify sir or ma'am on the cell phone. Would you identify yourself?
Oh, me? My name is
Can you hear me?
Tiffany Thompson.
All right, Ms. Thompson, thank you. Just on the audio cell phone, what's your name? That's number 4587. That's you, sir?
Hello?
Yeah, what's your name?
Aquarius.
I'm sorry, I didn't hear that.
Aquarius, Giroux. Can you hear me?
Yeah, I'm just making sure.
10:45.
10:45. All right. Yeah, so you're here for your 10:45, Mr. Giroux?
Correct. This is Anthony Flores, correct?
Yeah, yep. You're in the right courtroom. We're just calling some cases before you. All right, sir?
Okay, gotcha.
Yeah. I just wanted to make sure I knew who was in the Zoom courtroom. I don't see a Stiles Wells in the Zoom courtroom or in the physical courtroom. It would appear that the defendant, this was scheduled for 10:15. It is now 10:48. It would appear that the defendant, Stiles Wells, has failed to appear for the second hearing. Mr. Klug, how would you like to proceed?
Yes, Your Honor. Plaintiff would like to proceed with the default judgment. I'll place the terms on the record. Rent as of today's date is $5,144. Court costs $162 for a total amount of $5,306. The premises has been kept fit for defendant to reside in. To the best of plaintiff's knowledge, the defendant is not a minor, is not in the military, and is not incompetent.
All right. And you'll follow up with an order to that effect?
Yes, Your Honor.
All right. Anything else on the record in 23-01-294, Mr. Klug?
No, Your Honor.
All right, and then we're back on the record in docket 23-01-295. That's South Washington Park versus Larry Smith. Will the parties please introduce themselves for the record?
Well, Your Honor, Jeff Klug appearing on behalf of plaintiff, South Washington Park.
This is the time set for landlord tenant pretrial. There was initial pretrial held on June 21st. Defendant failed to appear at that hearing. It was been reset for a second hearing because of service by attachment. This was scheduled for 10:15. It is now 10:49. I do not see a Larry Smith in the Zoom courtroom. I do not see anybody in the physical courtroom. It would appear that Mr. Smith has failed to appear for the second hearing. Mr. Klug, how would you like to proceed?
Yes, Your Honor. Plaintiff would like to proceed with the default judgment against Mr. Larry Smith, and I'll place the terms on the record. The rent due and owing as of today's date is $3,013. Court costs $162 for a total amount due of $3,175. The premises has been kept fit for the defendant to reside in. And to the best of plaintiff's knowledge, the defendant is not a minor, is not in the military, and is not incompetent.
All right, you'll follow up with an order to that effect.
Yes, Your Honor.
Thank you. Anything else on docket 23-01-295, Mr. Klug?
No, Your Honor.
All right, you're all set on those cases. And then we have 23-01-297. That's South Washington Park versus Andrew Porter. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Jeff Klug appearing on behalf of plaintiff, South Washington Park.
And this was set for pretrial on June 21st, 2023. The defendant failed to appear at that first hearing. Was set once again for today's hearing. It would appear that the defendant has failed to appear for the second hearing. It was scheduled for 10:30. It is now 10:51. I've checked in the Zoom courtroom and Mr. Porter is not there. He's not in the physical courtroom. Mr. Klug, how would you like to proceed?
Your Honor, plaintiff would like to proceed with default judgment, and I can place the terms on the record.
All right.
Rent due and owing as of today's date is $2,636. Court costs $162. Total amount $2,798. The premises has been kept fit for the defendant to reside in. Plaintiff's knowledge the defendant is not a minor, is not in the military service, and is not incompetent.
And you'll follow up with an order to that effect, Mr. Klug?
Yes, Your Honor.
All right. Anything else on 23-01297, Mr. Klug?
No, Your Honor, and I believe that concludes my cases with you for the day.
I believe that's correct. So have a nice rest of your day.
All right, you as well. Thank you, Judge.
And then Mr. Herman, you're here on your 1030 matter?
I am, Judge. How are you today?
I'm good. How are you?
I'm well, thank you.
So we're on the record in, I want to make sure I got this. So docket 23-01367. That is Edward Rose Associates versus Tiffany Thompson and Geraldine Knox. Will the parties please introduce themselves for the record?
Richard Herman on behalf of plaintiff.
And ma'am, you are Tiffany Thompson?
Yes, I am.
All right. And is Geraldine Knox with you, ma'am?
No, she is not. That's my daughter. I'm at work. I couldn't take any time off to be at home where she is. Because I just started my job, so I was gonna.
All right,
do
this
it.
is the time set for a second hearing. The first hearing, we have you and your daughter as a failed to appear, so we set it for second hearing today. Ms. Thompson, you've been able to appear today for the second hearing. Did you want the opportunity to speak with Mr. Herman concerning some of this? This is actually the second hearing. It's set by the administrative order. It's actually it's actually a default hearing. I think you've heard that people don't usually appear once they fail to appear. Did you want the opportunity to speak with Mr. Herman about some of these issues?
Sure. I didn't appear the first time. It's like I said, I just started my job, so I couldn't take any time off, and I told the property manager, I called and left her a voicemail and told her that I couldn't appear because I just started my new job. And then maybe about a week or so later, I got this notice to appear in the mail. I didn't hear from her.
It's set for second hearing. You probably should contact the court to indicate you can't appear. But that being said, let's go. Mr. Herman, would you be amenable to meeting with Ms. Thompson in a breakout room?
Of course.
All right. Ms. Thompson, I'm going to have you placed with the legal representative of Edward Rose. And to see, this is a pretrial now. It's kind of turning into a pretrial. This is a default hearing. But for you to discuss some of these issues, all right? You've also got some other variables here. You can talk to legal aid. You can talk to somebody along those lines. But I want to make sure that you talk to Mr. Herman to see if you can work this out. All right, ma'am?
Okay. Okay.
All right. So I'm going to have Mr. Herman and Ms. Thompson placed in a breakout room.
Thank you, Judge.
Thank you.
Thank you.
Mr. Giroux, no, he doesn't need to join on more than one device.
All right. And so, Mr. Giroux, I've got you on. Oh, you're good on the cell phone. All right. You don't have to join by way of the other device in the waiting room. All right.
Gotcha.
All right. So you're good. You can join on one device, and I'll call your case in the next. Well, that's Mr. Herman's case. So I'll call your case as we get there. We're about 2 from it.
Okay. Appreciate it.
You're welcome. All right, so we're back on the record, 2301-367, and Mr. Herman, you had the opportunity to speak with Ms. Thompson in a breakout room?
I did. Ms. Thompson and I come to an agreement, a consent. So I'm going to take a default against Knox and a consent against Thompson. Same
All right.
terms will apply to Knox as with Thompson.
That's
Rent
my
to-
daughter.
Say what?
That's my daughter.
Okay, yes. So
Yep.
rent to retain is $3,028. Court cost $193.79. Total redemptive amount through July, $3,221.79. I'm giving Ms. Thompson and Ms. Knox until July 31st. To pay that, I have advised Ms. Thompson that she applied for SER assistance. And I've advised her to get on the phone with them today and tell them that she's on eviction status, and hopefully they'll speed things up. And Ms. Thompson, I don't know where you are in relationship to the courthouse, but I'm sure if you get down to the courthouse, they will give you a copy of your judgment and you can give that to SER. And that might work quicker than waiting for the court to mail it, to mail it to you.
Right. All right, so the default judgment is to Ms. Knox for fail to appear at the second hearing. And that's the same numbers, right, Mr. Herman?
Exact same numbers, Judge. Exact same time frame to pay. So we're not penalizing her.
Oh, okay, because
Yeah.
it's my daughter, and she wouldn't have come because I'm at work.
Yeah, no, I'm not.
All right.
There's no penalty for her not showing up.
Okay.
Right. And then the consent judgment, all the numbers that were discussed were the same numbers that you discussed in your breakout room, Ms. Thompson?
Yes.
All right. And the vacate date is the July 31st date. Is that correct, Mr. Herman?
That's correct, Judge.
All right. All right. You'll follow up with an order to that effect, Mr. Herman?
It will be emailed to you as soon as we get offline.
All right. And so what the court speaks through its orders. So when Mr. Herman submits the order, I'll sign it. You should get a copy of that for any rental assistance you might need, Ms. Thompson, because you're kind of under the gun here a little bit. You need to get this going pretty quickly, okay?
Okay. Is there any way that I can have that emailed to me so I can email it to them?
You're gonna have to come into the civil department to get it. Yeah, they won't email it out.
Okay.
How old is your daughter, Miss Thompson?
She's 22.
Does she have a car?
No, neither of us have a vehicle. We ride the bus everywhere we go.
Can she ride the bus to the courthouse and get a copy of that while you're at work?
I can try to get a hold of her. I was gonna, I was gonna go and it says 124 West Michigan Avenue, 6th floor. So I was gonna go, got out of work.
Okay. I don't know. Judge, what time are you open? What time's your clerk open till?
5 o'clock.
Okay.
Thank you.
Okay, so we're open till 5. We just want to make sure the ball gets rolling and you have enough time to do all this. All right, ma'am?
Yes, I'm gonna come pick it up after work, and then I can I'm gonna call them when I get off the phone with you guys, and then I'll go pick up that today after work and submit it to them.
And I'll pull it aside, make sure it gets to the civil department so they have it.
And is there a charge for that copy, Judge?
It's probably $1.
Okay.
Out of the civil department, yeah.
Just so you know that, Miss Thompson, okay?
Yep.
All right, anything else for the record? 2301-367, Mr. Herman?
No, Judge, I just want to wish you good luck, Miss Thompson, and
Well, thank you.
Yep.
Thank you both
All
for
right.
helping.
All right, Ms. Thompson, good luck to you, okay?
Thank you.
And then we're on the record in...
You can leave.
Okay.
Yeah, you're free to leave, ma'am.
All right, thank you.
We're on the record in docket 23013668. That's Edward Rose Associates versus Alyssa Stitt and Donta Boring. Will the parties please introduce themselves for the record?
Richard Herman, plaintiff.
This is the time set for a landlord tenant pretrial. This was initially set for 10:30. It is now 11:07. It would appear that the defendants failed to appear. Defendant 1 and 2 failed to. They're not in the Zoom courtroom. They're not in the physical courtroom. There was a previous pretrial held on June 28th. Defendant 1 and 2 failed to appear at that first hearing. It would appear that defendant 1 and 2 have failed to appear at the second formal hearing. At the second hearing, we did have service by attachment at the first hearing. Mr. Herman, how would you like to proceed?
Judge, I'd request a default judgment against both defendant 1 and 2. Rent to retain is $3,476 with $193.79 in court costs. So the total redemptive amount, $3,669.79.
All right. And to the best of your knowledge, Ms. Stitt or Mr. Boring are not a minor incapacitated or in the military service, and the premises was kept for its intended purpose?
That's correct, Judge.
All right. All right. So I'll issue that the order to follow concerning the numbers that were placed on the record and the failed to appear. Anything else for the record in 23013668, Mr. Herman?
No, sir.
All right, that's all for the record in that file.
I have a quick question though that has nothing to do with this, if I may.
Sure.
Attorney Klug, who appeared before me, is he a Lansing attorney?
Yes, he is.
Okay, perfect. Thank you. I need to contact him. I just wanted to know what city he was in.
Yeah. I'm not sure what his, but I'm pretty sure he's a Lansing attorney.
Okay, thank you, Judge.
And he's out of Okemos.
Perfect. Just as good.
Yeah, kind of the same thing.
Yeah.
All right, so we're on the record in 23013670, Edward Rose and Associates versus Brittany Bolhar and Keena Brown. Will the parties please introduce themselves for the record?
Richard Herman, plaintiff.
And this is the time set for a landlord tenant pre-trial on second hearing to appear on June 28th. Defendant 1 and defendant 2 failed to appear. For the first pre-trial, it appears that defendant 1 and defendant 2, that is Brittany Bowler and Keena Brown, have failed to appear for the second hearing. There was service by attachment at the first hearing. Check the Zoom courtroom, and there's nobody here by Ms. Bowler or Mr. Brown's indication or in the Zoom courtroom. Mr. Herman, how would you like to proceed?
Judge, I'd request a default judgment against both defendant 1 and 2. Rent to retain through July is $3,084 even, with $193.79 in court costs. So the total redemptive amount is $3,277.79 with a writ to issue if it's not paid on or before July 27th.
All right. And to the best of your knowledge, Ms. Bowler or Mr. Brown are not minors incapacitated or in the military service, and the residence was kept for its intended purpose.
That is correct.
All right. And you'll follow up with an order to that effect?
Yes, I will.
All right. Anything else on the record docket 23013670?
No, sir.
Yeah, you're all set on that. And then we have Mr. Joro's case. So Mr. Joro, I'm going to call your case on docket 23013671. That's Edward Rose and Associates versus Decarius Joro. Will the parties please introduce themselves for the record?
Richard Herman, plaintiff.
And sir, you are Decarius Joro? All right.
Correct.
This is the time set for a landlord tenant pretrial. There was a previous pretrial on June 28, 2023, in which the defendant failed to appear. we have service by attachment, so we set it for the second hearing. And Mr. Joro, you are now here at the second hearing, is that correct?
Right.
Mr. Joro, I can barely hear you. Can you talk in, is that correct?
Hello? Correct.
Oh, all right. So this is the second hearing. So I want to treat this somewhat like a pretrial, but I do want you to have the opportunity to second hearing. There's a legal representative of Edward Rose and Associates here, and at least at this hearing, you have the opportunity to speak with Mr. Herman to discuss some of these legal issues. Would you like to do that, sir?
I would.
You're gonna have to speak up. Is that a yes?
Yes, sir. If I may.
Okay. And so what I would do is place you in a breakout room with Mr. Herman. Mr. Herman, would you be amenable to speaking to Mr. Joro in a breakout room concerning this matter?
I would.
All right. So Mr. Joro, I'm gonna place you in a breakout room with Mr. Herman. Mr. Herman can go back to room 1 and I'll place you in room 1. The only thing, Mr. Joro, I'd have you do is make sure you speak up because you're a little hard to hear, okay?
Gotcha.
All right.
I'm
gonna
really
place
bad
you.
reception where I'm at.
All right, just keep talking talking right into the receiver and you should be okay. Let's see some of these. Cage I've got for balance of 246. It was set up, looked like a plan was set up. All right. How about Leanna Lynn?
She was $2 million. And I'm working on it for the last guy.
She comes out of a restitution hearing.
Yeah. She's got some problems, including a warrant and a bunch of pending cases.
All right. Raymond is
She's the one with the board. So she's definitely probably not sure.
Raymond. Well, that's it then, huh?
Yeah. Miss Raymack currently owes $636.
I think those are all going to bench warrant status. I don't know what to do about that. Did you want to put the other Joro in the room? The waiting room Joro?
I'm just gonna remove that.
Just remove that. I don't know what I think he was joining on different devices, but he's hard to hear. What's that? What's the file that it's Miss Taylor, right?
Hello.
The one that I want to Miss
Tiffany.
Yeah, Tiffany.
Thomas?
Tiffany Thomas.
He keeps joining, but he's in the breakout room. I don't get what he's doing.
Oh, maybe just stick him in the breakout room.
Stick all of his personalities in the breakout room.
He's not connecting the audio there. But... Oh, Mr. Herman's back.
Judge,
yes.
There you are. Okay, I'm sorry, Mr. Joro was having a problem getting back. I was going to ask you or your clerk if you had a way of bringing him back, but he did it himself. I'm impressed.
Well, I think we're just going to we have him on audio and video. I think we're going to put them both in the room.
You're going to put what?
Just in, yeah, he's got, so Mr. Joro, can you hear me? He doesn't have audio on his video.
Okay.
So his audio is with you in the room, and his video is here with us. But as long as you get some audio, we'll put all of them in the room with you.
Okay, so you want me to go back to my room?
Yeah, let's go back to your room and we'll make sure he's in the room too.
Without dessert? Oh, sorry. That's takes me back a ways.
There's
okay.
And you're gonna put him in the room too, right? Sir, on the number 4587, who is that?
The Aquarius.
Yeah, let's move you into the room with Mr. Herman, all right, Mr. Joro?
We had finished talking, and he was trying to get me to join back in the courtroom. We had finished up the talk.
Oh, so you're all set?
I'm not sure. I'm not sure if he relayed that to you or not.
I think he thought that. Well, I think he thought that you were still in the breakout room. Looks like he's joining us now. So
yeah.
So Mr.
George, sorry.
All right. So Mr. Herman, were you all done in the breakout room, or did you have more to do in the breakout room?
No, we're good. We're good, Judge.
All right.
Mr. DeJoro and I have agreed by consent.
Perfect.
That he owes $3,332.65 in rent through July, and that his court costs are $167.79. So the total amount he owes to get through July is $3,500.44, and I've given him until the 31st of July to pay that. I read him his rights under the court rule, and he did give me permission to sign his name.
So 31st of July is the vacate date. Mr. Joro, did anything said on the record that wasn't already talked about in the room?
No, sir.
All right. And you've given Mr. Herman authority to sign that consent judgment on your behalf?
Yes, sir.
All right. Vacate date on July 31st. All right. I will sign the.
There was
Go
one
ahead,
other
Mr. Herman.
thing.
Yep.
He promised me to give me his hair.
He's one of many then, Mr. Herman.
I know. I'll take it from wherever I can get it, Judge.
Yeah, I understand. All right, so the orders to follow on the consent judgment, authorization has been given to sign, and I will sign that when I get it. Anything else for the record in docket 23013771, Mr. Herman?
No, sir. Mr. DeJoro, good luck to you.
All right, you're all set,
Appreciate
Mr. Joro. Thank you.
Thank you.
And then, Mr. Herman, we have the last, I think this is your last case of the day.
It is, sir.
So we're on the record in docket 23013774. That's Edward Rose and Associates versus Tiara Bradley. Will the parties please introduce themselves for the record?
Richard Herman, plaintiff.
This is the time set for a landlord tenant pretrial. It was set for, we had a previous pretrial on June 28th in which the defendant failed to appear. We've reset it on this for the second hearing for service by attachment. It would appear that Ms. Bradley is not in the Zoom courtroom or the physical courtroom. This was set for 10:45. It is now 11:21. And it would appear that the defendants failed to appear for second hearing. And Mr. Herman, how would you like to proceed?
Judge, I request a default judgment. Rent to retain is $2,682.97. There are $167.79 in court costs, so that the total amount owed, excuse me, is $2,850.76. I'd ask that a riddle issue, if it's not paid on or before July 27, 2023.
All right. And to the best of your knowledge, Ms. Bradley is not a minor, incapacitated, or in the military service, and the premises was kept for its intended purpose?
Yes, sir.
All right. And I will sign an order to follow on that default judgment. Anything else on the record? 23-01374, Mr. Herman.
Nope, I'm good. Thank you.
All right, you're all set, Mr. Herman. It's good to see you again.
Yeah, likewise. Have a great day, okay?
You too. Take care.
Yes, sir. Thank you.
Call these. All right. So we're on the record in docket 20 L2561532. That is a show cause for Antonio Cage. He was show caused on a fail to pay a balance of $201. This is scheduled for 11 o'clock. It is now 11:25. It would appear that the defendant has failed to appear for show cause. And I'll issue a bench warrant and bond forfeiture for the financial debt. So that's all for the record in docket 20 L2561532. Then we're on the record in docket 22-03384. That is a show cause for Leanna Lynn. Came out of a restitution hearing of $201. $201. Defendant failed to appear. This was scheduled for 11 o'clock. It is now 11:24. I do not see a Miss Lynn in the Zoom courtroom or the physical courtroom. So with the defendant failed to appear for show cause, bench warrant and bond forfeiture is issued. And we're on the record in dockets 22 L2746991, 6992, and 6993. That is three different tickets concerning Courtney Raymont. This is time set for a short show cause. On Miss Raymond, she owes 186 on one, 264 on one, and 186 on the other. It would appear that this was scheduled for 11 o'clock. It is now 11:25. Here, the defendant has failed to appear for show cause, and a bench warrant and bond forfeiture is issued. And that is on 6991. And that's on 6993. And 6992. That's off the record on those three tickets. I'll sign all these.